Good afternoon, everyone. My name is Aurelio López-Tarruella. I'm the director of the academic chair for the responsible development of the Metaverse here in the University of Alicante. Welcome to the 7th webinar that we are organizing around different research lines that we have identified as the most relevant in relation to the legal aspects of the Metaverse. Today, we are going to be talking about virtual property in the Metaverse. We have a presentation by Michaela MacDonald, lecturer at Queen Mary University of London, that is gonna talk about a conference with a very interesting title, Final Fantasy, a roadmap for virtual property in the Metaverse. I will give the floor first to Michaela, and afterwards, after her presentation, as in previous webinars, I will give the floor to the two discussants that we have with us, so that they can give Michaela's their opinion about the topic, and she can take new ideas for the research paper that she's been working on this topic for the last few months. Finally, before giving the floor to Michaelas, I have to say that I'm here because I'm substituting our good friend Gaetano Dimita. We hope that he can recover soon and he can be with us in other activities of the academic chair. Michaela, you have the floor. Thanks a lot for participating in our activities.
Thank you so much, Aurelio, for the introduction and for the invitation for me to be here today with you. I'm just going to quickly share my screen. Everyone, please let me know if you can see it.
Yes, Michaela, we can see it.
It is working. Brilliant. So, welcome everyone for this session, the 7th in the series. As Aurelio mentioned, I will be focusing on a particular perspective when it comes to the metaverse, when it comes to digital environments, and that is examining user interaction and participation and experience in the metaverse through the lens of property. And when I'm talking about property, I'm very much considering property or theory of property distinct from intellectual property. So I am very much focusing at hierarchy of rights in the context of property and different types of things that can be considered property, that can be owned, where intellectual property would be, in terms of intangible objects, would be considered more of a subset category. So, in order to set the scene, so to speak, I think it's interesting to look at the concept of the metaverse as a space, as an environment that is inhabited and shaped by its users and citizens, digital citizens, and how much it potentially differs, or what characteristics it shares with different kinds of environments that we are already quite familiar with. So think about physical environments, think about the whole cycle and development of the internet, online platforms, social media, video games, and interactive entertainment. In that context, the metaverse as an idea that we're trying to build, design, and implement is really not that new. I would perceive it more as many other commentators perceive it more as a continuation of an existing trends. It's not something that we are necessarily inventing or reinventing from scratch, but we are building on the sort of existing notion of immersive and interactive environments that have been around for some time now. So thinking about the sort of nature or definition of the metaverse, well, there is little consensus in terms of what exactly it entails, what precise technologies will underpin the metaverse. There is an agreement around specific characteristics. We have recently published a report on the metaverse, in particular on the role of intellectual property in metaverse, but revising and reviewing the existing literature with regards to the development of the concept. There are some specific characteristics that can be highlighted as uniting the perception of the metaverse, and these include ubiquity, realism, so the sort of immersion and emotional sort of participation in the world that you inhabit, interoperability, meaning that you can experience the environment through different systems, platforms, that you can exchange information, data, objects, your identity within different ecosystems without any barriers. It's a seamless experience. Scalability, level of centralization or decentralization, and user-generated content. These are just some of the main characteristics that are sort of coming through the different concepts and ideas of what metaverse may look like and how it can be delivered to us as users and citizens within this space. To define metaverse in my own words, I'd say that it is a space that is significant in terms of connection, community, and identity. These are sort of the uniting features that underpin the concept per se. Again, building on existing types of digital environments that have been around for a long time. As I mentioned before, social media, video games, virtual worlds, and so on. In that sense, this concept provides a sort of extension to the existing physical and virtual worlds in a new way that creates a synergy and overlap of these environments in a way that it may be difficult to distinguish where physical world ends and the digital world begins. And when we examine these different types of environments from the perspective of property, I think that we can identify underpinning principles in terms of resources, valuable resources, and how these are allocated and redistributed through a set of informal or formal systems of rules. What do you think about society in a physical environment, from the very early civilizations to the modern times? What do you think about the early internet, or Mark Zuckerberg's vision of the metaverse? At the core, again, from the perspective of property, are valuable resources. Whether these are agricultural produce, timber, or precious stones, whether these are domain names, email addresses, whether they are video game avatars, characters, skins, virtual currency, there is a range of different resources that are often scarce either literally or the scarcity is introduced artificially into the environment. And we are trying to come up with a way, as a community, a society, how we can allocate and distribute these different resources. And we also have rules in place that determine what happens if you're in breach of these rules, and what are the possible remedies to address such breach. So in the context of how we organize ourselves within communities and societies, whether they are or exist in the physical or digital world, I think this is something that is inherent to us as humans and to societies in general. When looking at different theories of property, and again, there is a range of different theories of different philosophers and legal theorists, economists, etc., that are part of different schools of thought, putting forward justification for why we have property rights and why we have the property systems that we do. What is the motivation? What is the objective that they aim to meet? How do they meet or satisfy the need for fairness and justice in society? And when reviewing these different theories of property, again, some of the conclusions that I've arrived to is that property as a concept is inevitable. Even if the property system in place is not private property or personal property, even if it is communal property or identifies different types of objects that can be owned or excludes objects from being owned. Whatever the arrangements are, the concept itself is an inevitable part of social life, of how society functions, one of the fundamental underpinning institution of human interactions. And when society reaches a certain level of sophistication and the social interactions become more and more complex, there is, of course, the need to identify a system through which the valuable resources can be allocated, and how this aligned with the markets for these particular resources, and who are the different parties, what sort of interest they may have in these objects of value. Again, this is equally valid for communities and societies that exist in the physical world, as well as those in virtual environments. When we look at the development of video games in virtual environments, even worlds and platforms and games that did not have any system in place for transactions with regards to virtual items within games, whether these were, again, any sort of accessories or weapons, potions, particular skills, etc., that you could acquire or create within the game. Systems like this develop incidentally without the intention of the property, the video game provider. Even if it wasn't part of the design of the game, this is something that emerged so that players can provide for rules on how different items can be allocated within their group, within their community, in a way that they perceived was fair. In other contexts, players created secondary unofficial markets for, again, for items of value, whether these were weapons, as I said, potions, or virtual currencies. Players wanted to exchange or acquire items of value. Sometimes they were interested in acquiring these outside of the game rather than playing the game. It was easier if they could afford it to purchase these items themselves rather than engaging with the game. And so lots of different secondary markets emerged within the context of different titles, different video games, leading to scholars in the early 2000s measuring and identifying independent virtual economies within these virtual worlds. So ascribing particular value to different assets, how many of these are being traded by users, and sort of the potential profit that this generates. So as the societies and communities within the virtual worlds again grew in sophistication, and the interactions and transactions grew in sophistication, these markets developed almost by default. And then the question was, whether the game providers acknowledged it, accepted it, tolerated it, or pursued a very different strategy as to ban any transactions with regards to virtual items, virtual currency outside of the game. For instance, you were not able to purchase a sword in World of Warcraft for real money in an outside secondary market, for instance, facilitated by a third party. So some environments are and have been quite open. One good example is Second Life, which is sort of sandbox style virtual world initially designed around the idea of property, openly advocating for property and ownership, using precisely these terms and concepts in their marketing materials within the game, so you could click on the button to buy, to rent, to purchase, to sell, creating a whole set of expectations from players, inhabitants of Second Life, that they indeed are owners, because not just the language, the terminology, but the design of the environment, the existence of the objects separately and independently of the environment, of the avatar, the ability to transfer the objects from one to another in exchange for virtual currency, all that led to expectations, legitimate expectations, that indeed this is a case of where I am acquiring virtual property rights in these assets, which again are very much distinct from intellectual property. This wasn't a question of about copyright or any other intellectual property rights in those assets. So if the conclusion is that the existence of property as a fundamental concept is inevitable, I would argue that it is the arrangements of who can own or who can be an owner, what can be owned, under what circumstances, with what consequences. Those arrangements are something that I believe we can be much more innovative and imaginative about than we have been so far. When you look at how property, concept of property, is adjusting to new types of technologies, to new types of interactions, of our interactions and experiences, often we are using existing terminology and existing concepts and trying to apply them to these new types of objects of technology. So thinking about personal property, physical property, or ownership of land, and trying to adjust these notions in the digital environment is often quite difficult and doesn't really translate very well because the constraints of the digital environment are very different. One thing that needs highlighting is the fact of the dependence of the entire virtual world and everything in it, including your own avatar, any assets that you may have, on the underpinning technological infrastructure. That is the first dependence. If somebody switches the server off, there goes your metaverse, there goes your video game, there goes your digital environment, and there goes your assets and the whole range of assets and your access to them. Another type of dependence is then created by the set of intellectual property rights and contracts that underpin the assets that would include potentially any of the data, metadata, any creative expression that the asset may represent, trademarks, any patents, etc. So the object itself, the virtual object, whether it is a weapon in World of Warcraft, whether it is a battleship that you built in Minecraft, or a character that you've created in Roblox, will represent a whole hierarchy of rights that will often clash with each other. And that is before even introducing the concept of virtual property in the mix. So the question is at this point, how can we reconcile the fact that so far, and this is a conversation that has been going on for decades now, there is no recognition of digital assets in general as objects of property. Now, there are different steps that need to be taken for this to happen, and to then identify a sort of particular set of rights that the law would convey or define that what rights this particular type of property entails, and who can it be allocated to, what are the specific proprietary interests attached to it, and so on. There have been a number of attempts in the last few years to address this lack of legal definition, this legal uncertainty when it comes to digital assets, and this goes well beyond the scope of video games, interactive entertainment, and the metaverse. This conversation is reaching wide beyond those realms, because when you think about digital assets as a category of items, this can include anything from profiles, emails, any kind of content that exists or that you've created, any games, items, avatars, currency, digital files, ebooks, crypto assets, any sort of metadata relating to any of these types, and more. The issue with the category of digital assets is it's quite wide. It is changing, and it's very, in that sense, it's very fluid. So the first obstacle is, how can you define a digital asset in a way that is specific enough to be captured by the law. Remember, there isn't a single category of property law that deals with every possible type of object or thing that can be owned. We often speak about property and ownership in a very specific context. For instance, probate and inheritance, or divorce. We talk about assets and property for the purposes of tax law, etc. So there's always a very specific context in which we need to determine whether something can or cannot be owned and what the consequences are. So trying to define what an object, what characteristics an object has to have for it to be owned, again, is a complicated, it can be quite complex, and it will differ in terms of physical and tangible and intangible objects, where some of the requirements are difficult to implement, and they can be linked to a specific technological solution. When the Law Commission launched its consultation in the UK with regards to digital assets, they were looking at precisely this task. What are the different digital assets? Can we categorize them? What are the different characteristics that must be present for an object, including digital asset, to become an object of property? And is it necessary to change the law in the UK in any way in order to address potential legal uncertainty? Two characteristics that the Law Commission focused on as the sort of defining features of things and digital assets were excludability. So it must be possible for the object to exist on its own. It needs to be separate from a person. It needs to be separate from the legal system. It needs to exist on its own right, needs to be able to be excluded, alienated from one to another. And second characteristic that emerged as defining one was revalorousness. This means that it must be possible for the object to be used for the benefit of one person only at any given time. So when I am sitting at this table and on my chair, no one else can do that at the same time. It means that physical things are revalorous. It also means that in terms of ownership, you're able to possess them. And possession is one of the important elements of ownership. With digital assets, that is often complicated, but possible to implement, especially thanks to technical solutions and implementations such as blockchain, whereby you can simulate and create revalorousness as well. When the Commission reviewed this range of digital assets, they concluded that there's only one category really that meets the criteria as set out, and those were crypto tokens. So the inquiry, while reaching really wide and looking at lots of different categories of assets, ended up with focusing on only one small group of digital assets, which I think, in my opinion, reduced the value of the inquiry to a large extent. So in terms of where does virtual property come in as a concept and the problem that it is trying to address, is the fact that since the early 2000s, focus on the different scenarios where the absence of any provision or recognition by the law of users' rights in virtual assets, specifically in the context of video games, highlighted the sort of the frustration and lack of remedies available. The public focus on this debate around lack of protection of users' rights sparked by a fatal attack in relation to a theft in a video game. This took place in China, again, early 2000s. But it brought the notion of virtual property to the forefront of the public perception of how we interact in virtual environments with regards to virtual items and each other. While users may have had legitimate expectations about acquiring property rights or any kind of rights in the items as they go through the game, as they navigate the environment, it transpires, especially if you read the underpinning license agreements, if you inquire in the sort of wider remit of the law, that is not the case. So not only you haven't acquired any rights per se by either earning the items through play or by purchasing them with real-world money, exchanging them for another item with another player. None of these changes in status that are registered within the virtual environment translate to law. So they have no legal implications. And therefore, if somebody steals your item, if you would like to gift your item or asset to someone else, if you die and someone, your heirs are expecting to get access to your account and to your assets, that isn't possible because the law hasn't responded to, it doesn't recognize these events and these interactions. And this gap between perception, between expectation, between the experience of users within these again, very differing and wide range of environments has over time led to reports in the news, has led to quite increasing body of literature on virtual property, on rights in virtual items, and changes in law when it comes to virtual theft. Especially in China and other Asian countries where this particularly was rampant by the end of 2000s. And yet again, users are surprised every time there is an event that challenges their access, their right to their assets in games and online platforms, that they indeed do not own any of the assets in question. They might have a license, they might have a legitimate right to access and use those items as well as the game, but not no rights per se when it comes to the assets. And then we had the advent of the NFT, which promised to fix all these problems by providing a technological solution. So by the ability to use the non-fungible tokens as a sort of immutable record of a transaction, this would be a proof of ownership, proof of authenticity of both the transaction and the asset, and provide you with a sufficient protection with regards to your rights within the asset. So for some time, the entire hype around NFT was sort of riding on the notion that we don't need a law to address the absence of digital ownership. We can do that through technology, and NFT is the solution. Now we can all own whatever we want online, and we no longer have to worry about asserting our rights with regards to others. As it transpires, and as the hype sort of as the bubble burst, you cannot solve a legal and sort of socio-political problem through technology only. NFT does not establishes ownership with regards to the item that it represents. It is merely, if I'm to simplify, also given the time, if I'm to simplify this, is merely a receipt of a digital transaction that indeed you own the receipt, that is yours. There's no dispute about that, but it has no impact on your potential property rights or ownership with regards to the item, to the asset that the NFT represents. And I think that is a really valuable lesson to learn, that unless we have examined the justification of why we should have potentially property rights in virtual assets, how this concept of virtual property should look like, what consequences it will have, and how it will coexist with all the other rights within digital environments, within the metaverse. No matter what technological solution we will come up with, it will not address and solve the underlying problem, the underlying issues. There is no NFT for good governance and users agency within digital environments. In terms of particular questions that I think we should be asking with regards to virtual property, is there a sustainable digital future where in the metaverse, or whatever the environment may be called or look like, when we do not have rights in digital assets that are separate to intellectual property rights and contracts or license agreements, through which we could exercise the right to use and control our virtual and our digital assets in a way that is separate from the underpinning infrastructure, that is separate from the platform, that is separate from the digital service or the digital product in which we are acquiring these assets. And if we are to develop concept of virtual property, how do we overcome the very first hurdle of defining digital assets, where already we are struggling with sort of meeting one of the very, the main characteristics. How can we identify them in a way that is not too broad, not too narrow, that is very specific to certain technology, etc. And can the concept of virtual property counterbalance or trump the technological dominance and the dependence on the technology per se? And perhaps not a question, but a thought to close my presentation is that if everything is a right, becomes a right, then no right is meaningful. If we live in a digital environment, the metaverse, where the complexity and the hierarchy of rights is such that there is nothing left in the public domain, then none of those rights will have any meaning whatsoever, because we won't be able to exercise them in any meaningful way. And so when I started with sort of early civilizations and sort of human history and how, how property is crucial and the core of how we function as a society, I think one such similar catastrophic events when early civilizations ended and disappeared from the map, whether it was volcanic eruption or an infection. In the metaverse, this literally could be the fact that somebody switches off the server. And with that, I'm going to pause and open the floor to my lovely colleagues that are joining me today for discussion. Thank you.
Very much, Michaela. Very inspiring presentation. And in particular, those last questions that you have mentioned, I'm sure we will come back to them. Now I'll give the floor. I think Enrico already raised his hand. Enrico Bonadio is reader of IP at City University of London. Please, Enrico, I'm sure that you have things to say about NFTs, at least. So please go ahead.
Yes. Thank you so much, Aurelio. Thanks, Michaela, for presenting this very interesting paper. It made me think a lot about the categorization of virtual property and your focus on distinguishing virtual property from intellectual property, right? Let me, however, highlight a case that was probably one of the first NFT case in England. Of course, probably many of you are aware of this case. It was not a case about IP ownership of NFTs, because we all know that when you you purchase an NFT, you don't purchase any copyright or any other intellectual property right. But in this very early case, I'm talking about Osborne versus person unknown and Anor, the High Court here in London in 2022, so 2 years ago, basically, was one of the first, if not the first, decision, by a court on NFTs. The court basically compared the ownership of an NFT to something similar to tangible property, right? Even if we know the difference between tangible and intangible property. And I mean, what could be a common factor of both IP and virtual property is exactly the intangibility, right, of the assets, although several differences remain, as Michaela correctly pointed out today. But let me just summarize the facts and the finding of that case, because I think here it is interesting. So basically, the court held that there is a realistically arguable case that NFTs are to be treated as property as a matter of English law, right? So several commentators raised their eyebrows when reading this finding. What happened in this case? Just summarizing in 1 minute. There was this lady, this Osborne that had opened an account in this peer-to-peer NFT marketplace. Ozons was the second respondent. And in 2021, various NFTs representing the digital works of art were transferred to this Miss Osborne's account by a third party. And subsequently, what happened was that persons unknown removed NFTs from the account of this lady without, of course, her knowledge or consent. And following inquiries, it was uncovered that the NFTs that we used to belong to this lady could be traced into other, accounts opened by the defendants. That's why this lady, Mrs. Olmos, started legal proceedings before the High Court, first against unknown persons, with the objective, with the target to freeze the NFTs that had been basically stolen, right? Or at least this was the perception of the court, stealing NFTs from her account. And also, she sought an order against the other defendant, Ozons, requiring the defendant not to allow any further transfer, any further theft of these NFTs in question. And that was the case. Of course, was a preliminary case, and but some commentators hurried not to and said, no, look, NFTs are a kind of property, it's a new property, right? Of course, we were in the crazy days of NFTs probably at the beginning, right? Now the hype has a bit decreased a bit, but probably, I don't know if the judge might have been influenced by the hype of the moment or not, but it was quite a strong, I need to say, quite a strong finding, although in a preliminary proceeding or in the very first case regarding NFTs. So another, I think, issue that we should be taken into account, and I've done some initial research in the past months on that, is that several trademark owners seem to treat metaverse virtual world objects as kind of property in the very same way they treat tangible property. And I'm referring, for example, at some trademark applications filed by companies like Nike, Gucci, and also McDonald's. It seems that these companies have already filed and registered trademarks in connection with virtual goods and virtual services, also with a view to sending a message to the trade, to the market. No, we are innovative, showing that you have registered, you are applied for trademarks in connection with virtual goods, with virtual products, could give consumers the perception that this company is very innovative, is embracing cutting-edge technologies, and so on and so forth. So it is also used as a kind of marketing tool, right, to send this message to the market. So, for example, I have found in my research that the following classes of goods have been mentioned in the application, right? Downloadable virtual goods, namely computer programs, retail store service in class 9. Then you have class 35, the NIST classification class, retail store services featuring virtual goods, online non-downloadable virtual goods and non-fungible tokens, as mentioned in the classes of products in the trademark application, right? And then if we look at McDonald's filings, McDonald's, the fast food giant, has recently filed several trademark applications in different trademark offices for a metaverse restaurant where users can order food online, so in the virtual space, but for real life delivery. So I guess this attempt by McDonald's to merge the two parallel worlds, right? Virtual world and real world, I think is indicative of the willingness of these companies to treat virtual goods as real goods. Because then when you go to the metaverse and order your Big Mac menu in the metaverse, after 30 minutes, there will be the guy ringing to your door, the bell, and delivering the Big Mac menu, right? So this is the reality. And it seems that several consumers are using it. Not a majority, of course, but what do we know? Maybe in a few years' time, this way of ordering services and products might intensify, right? The same, I mean, there are several other issues. For example, the use of real-world trademarks in video games that simulate the real world has already been a source of disputes and debate, especially in the US jurisprudence. I'm just referring to one case which came to my knowledge recently. It is a case, ESS Entertainment 2000 versus Rockstar Videos. In this litigation, the question was whether a virtual representation of a real-life strip club in the popular video game Grand Theft Auto, whether this virtual representation of this shop violated the club's logo and trademark rights. Well, the court in America ultimately decided that the depiction of this strip club in the video game did not violate any trademark rights because it was protected under free speech, under the First Amendment clause, as Michaela remembers. So the free speech defense could be raised by defendants, especially when the trademark is not strictly used in the metaverse in connection with the economic activity, with the trade activity. Although the line between the two scenarios might be blurred. I mean, what if an avatar in the metaverse uses a t-shirt, right? Which represents a trademark. Is this a use in the course of trade that could be infringing? For example, a trademark for a third party. We don't have case law on that. On the one hand, it might be free speech defense, right? Following this case law. On the other hand, it might be considered, broadly speaking, a commercial activity, especially if there is advertising activity on the metaverse, in the platform, right? So I hope the case law will further give some clarifications. Let me just conclude my comment with another, because I focus on trademark rights, another potential area of dispute will be with reference to to image rights, personality rights, because of the tendency of using avatars which might be similar to famous celebrities, right? Could famous celebrities here enforce their image rights in different legal systems? For example, in the US, we have publicity rights. In the UK, we have passing off, which is can be relied in order to protect the images. But anyway, whatever the legal means, it might be the case that celebrities might see their persona as a property, right? Like they did in the physical world, right? We had cases, especially in America, where celebrities have sued socials, have sued the people who resemble like them, or they have the same voice, because they treated images as a form of property. So it cannot be ruled out that in the metaverse very soon we will have cases started by celebrities against whoever appropriates their image, and they might consider the image as a form of property, right? So I could go on and on more, but it's better if I shut up now. And but let me congratulate again with Michaela, because it made me thinking a lot about especially the difference between virtual property and IP, even if, as I said, there is a commonality. They are both intangible, IP and virtual property, in the sense that they cannot be touched in the very same way you touch a glasses or a wallet or any other tangible good. So this is my 10 cents on this. And thank you so much for giving the opportunity to comment on Michaela's paper.
Thanks a lot, Enrico. Michaela, you want to answer now, or you want to wait for Fabrizio's comments
I would just add a reflection on what Enrico has said. What he has highlighted is one of the difficulties that I talked about towards the end of the presentation, and that is the multiplicity of rights within a single asset. So the underlying copyright with regards to the code, graphics, any sort of textures, and any other sort of visual aspects of the asset, any functionality that can be protected potentially by patents, any trademarks that can be inherent within the object, the underpinning contractual framework that is absolutely necessary for you to be able to get access, because intellectual property rights are negative rights. So if you want to grant permission to someone to use and access those assets, that has to be through license, by granting that permission, and that then exists within an ecosystem that functions thanks to the technical infrastructure. So somebody owns the servers, somebody runs the engine, etc. So there's a lot of different layers within the environment in which that asset exists, all of which are sort of represented or impacts the access to and use of the asset already. And if we were to introduce into this equation a concept of virtual property, where the user would, or the player, digital citizen or metaverse citizen, were to acquire property rights in addition to all these other rights that would grant them control over that asset. And I'm specifically using the term control and not possession, because possession is very difficult in the context of digital environment. So that would grant me control. This would have to then sit somehow with all the other rights that already exist and are inherent to that asset, rights that are often exercised by potentially lots of different people. So is my property right in a virtual asset, does it trump the property right in the owner of the server? If they decide not to run the server anymore, how does that impact the existence of my asset? Then I need to be able to take my asset somewhere else that can potentially infringe the intellectual property rights in that asset, unless we have full interoperability within the metaverse where this is possible, which I think, again, intellectual property rights and interoperability are almost opposing concepts. Intellectual property rights are all about exclusive legal monopolies, whereas interoperability is the opposite side of the spectrum. So I think there's a lot of interesting conflicts in how this hierarchy of rights can actually function, and whether by introducing a new type of right, we will be able to rebalance the relationship between users, players, citizens, and everybody else, or it will become such complex, unworkable set of interactions, it will change nothing. To a really quick comment to the case that you've mentioned with regards to whether NFTs are property or not, even if the court ruled in favor of, yes, this is a type of property, and they have issued, I think it's called banker's order in order to recover the property. As far as I know, and I can be wrong, this had no practical impact. I don't think the NFT was recovered. I don't think there are practical means to actually to do that anyway. So what is the purpose of recognizing a right when the remedy is only theoretical and it doesn't change practically anything if I can't enforce the right, exercise the right in the specific environment, because blockchain is anonymous and I have no way of identifying the person that is behind potentially the theft. I have no way of enforcing it. The only way of doing that is by forcing the provider to step in and somehow manage and exercise the control on my behalf, potentially, and only to some extent. So it's just to add to the practicality of recognizing property rights, specifically in NFTs or crypto tokens in general. Fabrizio, over to you. I don't want to take too much time.
Yes, now it's time for Fabrizio Esposito, assistant professor in Nova School of Law. I have to thank Fabrizio, and I have to remind everyone that they are doing a great job in Nova School of Law in things or studies concerning the metaverse with Fabrizio and Vera Lucia Raposo as well. So please, Fabrizio.
So thank you very much. I would like to start. So contrary to Enrico, who kept it very, very focused, I'm gonna go all over the place. So I think this is a good complement to his comments. I would like to start from the title. This is a personal curiosity. Why Final Fantasy? It happens to be that Final Fantasy VIII is the video game that is most dear. Recently remastered for Google Play, so people, you can download it. 22 euros, it's money well spent. Anyways, and this prompted, however, also, I went down a rabbit hole when I started asking myself questions about my relationship to the things that my characters had in that game. And I think this is important because I completely agree that there is a very important perspective on these kinds of issues is the expectations that people have with regard to what is going on. Now, a small question here is whether, because Michaela uses legitimate expectations as an expression, whether reasonable expectations would perhaps be neither, especially considering that Michaela does not seem to be particularly impressed by the paper from legal positivism as a school of jurisprudential approach, so maybe reasonable would fit better in that regard. So I was talking about my beloved Lionheart sword that costed me a lot of effort to gain. My relationship with that object was never a relationship that I would qualify as property. I never understood myself as being able to use it outside that context. And I think there is a claim here about the fact that I do not have expectations that I can remove my house from the condo where I live, even though my neighbor, now I have a new neighbor and he owns a snake, and I would like not to have to deal with this fact, right? So this is also part of the expectations that I have. So maybe not being able to migrate outside of the server is a part of the expectations that people reasonably should not have. Okay, but then there are complementary expectations about how the server should be managed, right? In the same way in which I may have claims against the municipality of Lisbon if there is a landslide from the hill beside my house because the hill was not be properly maintained and my house is destroyed, maybe I can have legitimate concerns about how the server is maintained and whether the decision of closing it is justified on the basis of what our original agreement was. And maybe here an analogy could be made with other types of commercial horizontal property. For example, I was thinking about owning a shop inside a shopping mall, right? If other people start moving out and then the fixed cost becomes so high, everyone will essentially move out. But it would be possible theoretically for me to keep operating it, but then I would essentially have to somehow bear the entire cost of the whole operation. So I think this is important because we need to make as many efforts as possible to relate the novelty to what is already going on. And in this regard, for example, I have not seen it, but I would find it congenial to see some discussion on owning NFTs built on the idea of trade documentation, right? So tradable bill of lading and so on in international commerce that have been used since the medieval times in order to represent and transfer property, but being well aware that there was some underlying asset that was properly the object of property. Another thing that I would this is as a legal claim I would resist, namely the claim that we should not pay so much attention to contracts as a legal institution to organize these kind of human interactions. Think of FIFA. The whole professional football world is built on contract. And the fear that you will be expelled from the competitions that they manage and they are associated to them if you don't comply with their rules. Recently, the Court of Justice has reminded us that even if it is built on contracts, these contracts have to comply with some public law principles, but it is still contract. It is a regulated contract, it remains a contract. So the possibility that some of the things that are going on with NFTs on blockchains that can be problematized from a property law perspective could be framed as in personam obligations that you have vis-a-vis the blockchain owner, manager, and so on, so that if you don't comply, your account is terminated. Or any other proportionate sanction if we want to apply, as we should, principle of proportionality to private sanctions as well. So, and another reason why the contract law perspective is important is that we can use the contra proferentem rule to stick it to the people that when it comes to marketing, they tell you that it is ownership, that you own the asset. And then when it comes to the terms of the service, they say, I maintain the control over the blockchain or over the metaverse, and I can shut it down wherever time I want, or I can restrict your access rights under no constraint. Well, if you told me that I have ownership, you have created expectations in me by activating in my mind certain forms of human interaction. And now you need, and the moment in which you create a conflict between these two perspectives that are generated through the contract, this triggers the contra proferentem rule, which protects me, the weaker part in the relationship, against the ambiguity that you are trying to exploit. But another thing that I would like to say And then maybe there would be small points here and there, but I think it might make sense to open the floor for the audience, because we have a lot of people and we should benefit from that. Has to do with being really careful about using these notions, these very basic notions that I have been using as well. So I am also guilty of this. We need to be really careful when we talk about property, ownership, and contracts, and consumers, and so on, because as Enrico was pointing out, was handling in his own reactions, we need to be careful in which jurisdictions there are always nuances. The example that I like to give, in Italy, contract is not marriage. In Portugal, contract is marriage is contract, because of the way the definition and the nuances and so on. So we need to be very careful when we use these labels, because the cultural expectations that they convey in different parts of the audience will be different. And they will be related to stronger or weaker, for example, consumer protection mechanisms that will come into play depending on the jurisdiction that you are operating into. And I would leave it at that.
Thank you very much. Go ahead, Michaela. Yeah.
Thank you so much, Fabrizio, for your comments. I will probably start with the last one, if that's okay. I think that's an amazing comment, and especially if we're thinking in the context of the metaverse. So whose principles and interpretations and jurisdictions will prevail in the metaverse? From which perspective will we be looking at them? If you take, as an example, if you take license agreements, a lot of them are drafted in a very, similar way. They're using the same concepts, even though they are obviously, they exist and are being enforced in lots of different jurisdictions, and users are agreeing to them from lots of different jurisdictions. But through almost standardizing terms and conditions, some concepts, specifically in terms of copyright or contract, has been almost exported from the dominant US jurisdictions to elsewhere, because those are the companies, or the majority of companies, that provide the infrastructure, the services, the products, etc. So when we are using terms, concepts such as contract and property and ownership, these will have different connotations, they may have different meanings, they will be defined differently in law, in individual jurisdictions. And then when you think about property as a concept, family law will look at property differently, insolvency will look at property differently, succession law will look at property differently. So even then, we do not have a singular definition within the law of what is an object of property, what are, an exclusive set of rights that fit within that concept. So it is true that this presents a significant hurdle to overcome, even when having a conversation about what such concept would even entail, how would it look like in practice, and whether me coming from a continental civil law jurisdiction and someone coming from a common law jurisdiction will manage to see it in a same way. Then to your question about, or comment rather, about contracts, the potential of contracts. Clearly, the potential is huge, because almost everything that we do online is based on license agreements. Not only they grant us the permission to access the platform, the service, the products, to use all those assets within games and the metaverse and any other environment, but they also include references to how, code of conduct, any things that are prohibited or permitted in that particular environment, and they will differ. They will tell us what we can or cannot do, what we can or cannot say, how we can behave with each other. I would argue that contracts are not necessarily devised for that, for governing behavior among such a large number of participants on such a large scale for now and in the future, where I don't even know who the other participants necessarily are. I think that contract is being used in this context as a sort of one-stop shop, addressing lots of different legal questions and issues that are not necessarily suitable for this type of contract. Furthermore, so contract of adhesion, where I am presented the terms and conditions, either take it or leave it if I want to use the service. Personally, I think it's an issue that we don't read license agreements. At least I don't really know many people that would do that on a regular basis. And again, given the impact that they have on our everyday online interactions, I personally think that is a problem. And I think, again, that we could be much more imaginative in our approach in conveying the governance mechanisms present to those that engage with online digital virtual environments and engage in digital interactions with each other. Presenting this kind of document, and whether it's license agreements or cookies policy, privacy policy, etc., is often just a tick boxing exercise. There are no, genuine ways of encouraging people to engage with those rules in any way. Now, I know there are colleagues that believe that this is not a problem because it's very similar to, the real world. We don't go around the real world and living our lives understanding all laws and regulations. The only time we really need to know them is when a problem arises. That is usually the moment when we do need to know the law. But otherwise, we are perfectly okay to go through life not knowing any laws or regulations whatsoever, and we can function. I think the issue in this context, in context of digital environments, and specifically property, or the lack of it, is the gap between what we may expect is reality and what the law and the contracts actually say that is reality. And I think this mismatch is the problem. If we engage, and your example from Final Fantasy, actually, about some of the virtual items, it's not necessarily about whether I can take the items or assets out of the context of the game and use them in Fortnite or rebuild them in Minecraft. The point is, however, that the whole idea of Metaverse is built on precisely that I can do this, and it would be okay because it's interoperable and seamless, and it will be part of my virtual identity that can exist anywhere without limitation, including all my assets, objects, currency, history, contacts, communications, etc. But even if we stay within the context of one game, one ecosystem, the problem will arise when something happens to my stuff. It gets stolen, it is removed by the game provider, the provider decides to shut the whole environment down or replace it with something entirely different. What then? Do I have any legal recourse? At the moment, very little, if any, and that would be mainly consumer protection, potentially contract in the sense that, again, from the perspective of consumer protection, I can argue that some of the terms, some of the clauses are unenforceable because it's a contract of adhesion, etc. Increasingly more, because video games are shifting from being digital products to being more similar to digital service, I think the focus on consumer protection has increased. There is push for providing consumers with more information, with strengthening their position, especially in terms of receiving the service that they were promised, potentially through marketing, advertising, etc. So to really meet those expectations that were created. ensuring that the service is of the quality as promised, seamless, uninterrupted, there are no bugs, etc. And potentially, recompense the consumer when this is not the case. Whether it means that you can stop from your items disappearing, from the game disappearing, from the environment not having the features or assets that you are expecting. I think that is something yet to be tested. Usually the cases, and there are a few cases, the one that you I think it was you or Enrico mentioned, Bragg versus Linden Lab. Again, 2000s, I think, or yeah, the first decade of 2000s, a lawsuit against Second Life that has made exactly these, statements about ownership, property, created a set of expectations, and then removed the account of one user, Mr. Bragg, because he was in breach of the rules of the game by acquiring assets through an illegal auction. And he pursued to sue Linden Lab, arguing, well, this is my property. You can't just, you can't just terminate my account and remove all my assets from me because you said I own it. The case was settled outside the court, but the judge at the very beginning of sort of introducing the case said, this is a case about virtual property. This was very early on in the debate about and on virtual property and what it may entail. And I think there was a danger this setting a precedent that would not be appreciated, especially by the rights holders and providers. So I think there is definitely a mismatch and a gap between how we interact with items, assets of any kind in digital environments, how we believe we exercise control over them, and yet this control isn't translated into the underpinning contracts or existing laws. And if it is, in rare occasions, such as at the moment, a number of cases in the UK with regards to NFTs, the question is whether that has any practical impact whatsoever. I hope I've addressed your comments and questions. I did type them down, so hopefully.
Okay. I don't know if you have a second round of comments, Enrico and Fabrizio, but if that is the case, I would like you to take a look at the chat because we have two interesting questions, quite long, I have to say. But if you can try to answer them. Let me just make two comments in relation before while you read those questions, and is the following. One of the thing that has been mentioned in this question by Ana Cecilia is that we cannot expect virtual property to be exactly the same that physical property, and that is correct. It is true that in the very beginning of the digital era, let's call it like that, our expectations when we were purchasing virtual properties could not be the same that with digital property. But it is my opinion that we cannot follow with this theory anymore, because at that time physical property was an exception. Everything was physical property at that time. Virtual property was an exception. But nowadays, our virtual property is increasing in value. And if we are still thinking that this is an exception and that everything, our expectations when we purchase that physical property is what the contract says, a contract that is unilaterally imposed by a platform, I think that that is not a solution. I mean, there should be something in the law that establishes at least a minimum of rights concerning that physical property. And this brings me also to something that was mentioned by Fabrizio concerning the concepts, which are different from a jurisdiction to another jurisdiction. And I will use exactly the case of Osborne as an example, because one of the questions in Osborne was, according to what law do I have to decide whether there was a fraud or not with this case of the virtual currency? And if I remember well, what the judge did was, well, let's say the plaintiff has her residence in the UK, then we will make the fiction that the property, that means the virtual property, is located in the UK. So we will apply UK law. So we will bring everything to UK jurisdiction and follow the concepts of UK law. I have to say that sometimes we do not really appreciate what we have in the European Union. But in terms of law, it's extremely interesting because thanks to all the harmonization of the law or the directive of regulation, we have uniform definition adopted by the Court of Justice, which brings legal certainty to companies making business in the digital environment, and also to consumers that purchase things, purchase goods or services in the digital environment. I think that's something that we have to put into value. And I don't know if you have read the questions. Probably I already answered the second one of Ana Cecilia. But the first one is quite interesting, and is whether if the Osborne case could have been approached from a different perspective, not as a case of fraud of virtual property, but as a case of data protection. In the sense that when it would most of the time mean that the account has been hacked, which could be considered a confidentiality breach.
If I can
What do you think?
If I can just say one comment, I don't necessarily will answer it from the perspective of hacking the account, but of course that one aspect of some, potentially most of the assets in question, digital assets in question, is some form of personal information that I am conveying in order to create the account, or reflected in the underlying data or metadata that underpin the asset itself. But it can also include, as Enrico mentioned, my likeness, any other aspect of my personality, etc. Some countries do not have personality or image rights. Some countries do, and again, the range of legal remedies for breaching these rights varies. But there is one specific, I think, area where potentially privacy and or personality rights could address the control over assets, especially in question when dealing with post-mortem assets. So something that is part of a person's deceased person's estate, or control over how my image likeness is going to be used after I die. Can data about me be turned into a hologram, an avatar, and used by others in perpetuity when I'm no longer here? What are the legal mechanisms available to me now to do that? Would that fit within the remit of data protection / privacy law? Do we need another category of law to address this? Because again, these will be embodied and exist as various virtual assets and objects in the digital environment, in the metaverse, I can live on even when I'm no longer here. So I think there are aspects of data protection and privacy, but again, it may not be suitable to cover all the different range of assets. And in case of accounts being hacked, etc., that is a cybercrime. So we already have laws addressing that, and it isn't necessarily connected to notion of protection, but to access to computer and information stored in that computer, and that access being without authorization.
Mm-hmm. Fabrizio, Enrico, something else to add? We have like 3 minutes each.
No, just I also had in my notes there was also a point exactly about succession laws, right? Because it's also something that Michaela mentions, and based on the sociological approach that essentially she is proposing, what are people doing out there, right? Because there are people that die every day who have social media accounts of all sorts. So there are already established practices in this regard, and I also found quite interesting as well the perspective. I know from a cybercrime point of view, although it's not my area, protection of accounts, personal data, and so on and so forth, and is something that is quite well developed. Ransomware, right? So all these mechanisms, and I think it's conceptually defensible that, and this is the larger conceptual point that I wanted to make perhaps before. It is clear to me that when Michaela speaks about right, she speaks about them in the pre-refined, non-Ofeldian sense, right? Because in the discussion regarding the Law Commission of English and Wales, it became apparent the concept of property includes the power in a more precise sense to transfer the property right over the asset. So in some sense, it is maybe criminal law already establishes some of the entitlements that we normally associate to the concept of property. And if that's the case, then you can start building from there, pointing out like the Harvard Law and Economics property scholars would claim that property comes into bundles that are internally coherent from an efficiency point of view, so that if you establish that some property entitlement exists, then it becomes reasonable to claim that also others would exist. So this would be a different mode of justification from what people expect, right? Because this would be more related to what is functional to have together with something that has already been established by law, which would be a way to claim from somewhere in between the external and internal perspectives that there are systematic reasons why additional entitlements should be made explicit. 4 minutes, I'm sorry.
Let me
go ahead, Enrico.
Just one little, because we haven't talked about patents, but it seems that patents have also been applied for and obtained in relation to metaverse related technology and blockchain technology. Just give you some examples of patents that I found in my research. In 2022, the USPTO awarded a patent for the world's first digital vaccine, which works on reinforcing healthy behavior in the virtual world to promote the same behavior in the physical world. You know that the US Patent Office is quite generous when it comes to patenting things and stuff. I'm not sure whether this invention would be patented in Europe, but I mean, even looking at patents, we can still acknowledge this willingness or tendency to compare virtual, property to the physical property, or at least intangible property in the physical world. I give another example. In blockchain technology patented by Nike in 2019, within the sneakers, the physical sneaker, to provide customers with proof of authenticity of the purchased shoes, which again brings us to the function of the blockchain, not to give certainty, to give information authenticity. So I just wanted to add this because we had not mentioned patents, but it's another intellectual property right which is quite relevant when it comes to these platforms, right?
Yes, there are some comments about your simulation of a vaccine patent invention in the chat. We have to recall as well to the not so young anymore that there was a patent about the possibility of transferring digital assets. Remember the Redigi case, where it was a patent in order so that you can transfer a song to someone else, and the former owner did not have access to the file anymore. So this is a system that can work perfectly in the metaverse in order to facilitate the transfer of property, or to assimilate virtual property with physical property. But probably we will need another session to discuss that. First of all, just to conclude, thanks a lot, Michaela. Thanks a lot for your presentation. We are looking forward for the paper, and also to Fabrizio and to Enrico for bringing your comments from Lisbon and from London. The last thing that I have to mention is that this is the last webinar of the academic chair before the summer. In June, we have an incredible, I have to sell it, so it's an incredible international congress in Alicante on the 13th and 14th of June. You are all invited to attend to Alicante for that meeting, for that congress that is called Towards a Responsible Development of the Metaverse. We have a call for paper that is already closed. We are about to choose the best paper so that they can make the presentations, and we hope we will have a great time. That will be the last event of the academic chair in this first semester of 2024, but many things will come in the next semesters. Again, thank you very much, guys, Michaela, and goodbye to everyone. Keep in touch. Bye-bye.